seated. Thank you, Mr. Sargent. Can you hear and see us? Yes?
Yes, I can hear you. Thank you.
Thank you, Mr. Futrell.
Please, Commissioner. Mr. Sargent, if you've got your statement there, please.
Yes, what page?
Page 15, paragraph 36 of your most recent statement.
Yes.
In that paragraph, you've outlined a number of factors that weighed in favour of, in your mind, I think, of removing the inspectorial presence in 2015. Can I just want to ask you some questions about each of these reasons? Looking at the first one in paragraph 36.1, and that's about how to best use the effectively the resources of the department, isn't it? In other words, how you're going to use the departmental officers' time, as in those departmental officers available for this function. Correct?
Yes.
And is what is driving that reason, in effect, that there are finite resources of the department available to allocate to, amongst other things, regulation of the casino and other activities of the GWC?
Correct. Yes.
All right. Now, the next one, which is we touched a little on before lunch, which is the surveillance being implemented at the Perth casino. In what way, I'm still not quite sure I understand, in what way that necessitates a reduction in the inspectorial presence?
Well, the only thing I can recall is the fact that the surveillance technology is at such a quality that you can always recall or recover any activity in the casino. That's my understanding of it at this point. No, the quality of the recording is very, very good.
So is the point being made then, you do not need to be there watching it in real time in order to have access to essentially the same surveillance information that would be available if you were there watching in real time?
And correct. And if a inspector was to have a particular task to do, which relied on the technology, they could access that technology. They still have access in their own right.
All right. You mentioned earlier that the casino operator makes recordings and holds them.
Sorry, what was that?
You mentioned before lunch, in answer to one of my questions, that you understood the casino operator kept recordings of the surveillance at the casino.
Yes, well, I had to under the directions they had a time frame.
Do you know of your own knowledge if the departmental officers at any time have requested to review recordings?
No, I couldn't answer that. That's never been brought to my attention.
Did you understand it to be part of the functions the inspectors would perform, that requests would be made from time to time of the recordings and they would be reviewed?
Yes, I did.
And does that fall within the auspices of an audit function?
Well, it could be. That could be, or there might be an investigation for something that's come up.
All right.
They have to consider.
Okay, so, all right. The next paragraph I want to ask you about is 36.3, which is this shift to a risk-based approach to regulation. Can you just explain, if you don't mind, what you mean by a risk-based approach to regulation?
In this case, it was risk-based from the point of view of the maintaining integrity of the gaming on the footprint. So you could assess the risks of something not being followed in relation to a game or some other misappropriation. That's my understanding of what was being focused. We were looking at the footprint per se, rather than the issues you were talking about with respect to criminality, but coming onto the floor.
I'm actually more interested in what you understand the meaning of risk-based approach to mean in this. So you speak of a shift towards a risk-based approach to regulation. What do you?
Well, it moves away from even more so from just having a physical presence and everything to be done, but there are some things you would not do because you assess the risk as not being very high. And even things like the seals on gaming machines, etc., who controls them, the risk involved in the inspectors controlling that is minimal. Same as some of the gaming equipment, which at one stage in the early days, if a casino wanted things, they were actually held by the inspectors, but that shifted over time. So that's what I mean by risk-based. You assess what's the risk of something going wrong. Why can't the casino have its own internal controls on to place that, and we can assess those controls. That's my understanding.
All right, and when you're talking about a shift in Australian jurisdictions, are you meaning? Is that by implication in respect of casino regulation or regulation more generally?
I mean, particularly casino regulation. We weren't in the same situation as other jurisdictions with respect to gaming machines outside the casino.
And sorry, I've been asked to ask you to slow down again, Mr. Sergeant.
I'll bring my slow bit notice.
Yes, I think you may need to. Now, was the shift in Western Australia, if I could put it that way, towards a risk-based approach, a policy decision made by either the Minister or the Department?
I'd say more the Department, and definitely not the Minister, would have been the Department.
So was there a policy-based making process?
I don't think there was a formal decision. The move from the risk had been going on over time, even the 2002 change, and there was some changes within that period. And again, so it's not something that was just happened one day no, one day yes. It's a matter of over time. So it was a progression, but there was no sort of we're going to be risk based now. I can't say that happened in any particular instance. It was over time.
There were no changes to the Act or regulations that drove the change in approach?
No.
All right. Now the last sub-paragraph you have there, which is salary limits imposed by Treasury and the need to cut back on inspectors incurring penalty rates and mileage allowances. That's a financial constraint on the department's resources that you're referring to there, is that right?
Yes, it is.
And could I ask you to go, if we could go back to the paper that was presented to the GWC on this, which is GWC.0002.0016.0155 at _19. And could I draw your attention to two paragraphs on this page in particular? There's the second paragraph that commences continuing pressures, and there's another paragraph that commences changes to the operating environment.
Yeah, they're both broader issues to do with budgeting and the constraints the government was placing on us with respect to our budgets. It was more a departmental issue.
I understand that, but if you look at the first of those two paragraphs, there's a reference there to continuing pressures relating to the allocation of scarce inspectorate resources and in managing salary and operational budgets has meant that more changes are unavoidable. So is that by saying that essentially, given the resources available to the department, this change in the way we approach the inspections at the casino is unavoidable?
I would suggest the context of that changes. I don't interpret that we're going to change things even more at the casino. I do see it in the sense that we were looking at redundancies, etc., like that, and that might have some changes within the department. But I don't recall it being an issue to do with the actual programs at the casino. That's what we're talking about, the operational budgets, etc. So I see that more as a departmental issue.
Well, what do you mean by that? I mean, the department has...
Like you asked before, the question about was it a budget constraint which was imposed by the department? We were under the pressure in relation to our budgets, and salary limits, etc., were being micromanaged more by Treasury.
So, not to put too fine a point on it, one of the major reasons for promoting a change in the approach to inspections at the casino was a fiscal restraint on the department.
Well, it was a constraint we envisaged coming, and we did what we could in relation to the inspector. But changing the audit program didn't significantly save salaries in that regard. It did have some minor changes, but it was part of the process to get the maximum value out of their time in doing audits across the spectrum. That is, we had not only casino, community gaming, but liquor ones as well. But we knew the environment was coming, that if we didn't do something in relation to our overall salary budget, we wouldn't come within the limits, and that's why I've referred elsewhere. The fact we established a program of undertaking some redundancies. And the reason why we undertook those redundancies and didn't call on any Treasury money is that we needed our money to be able to give us flexibility to not to lose staff. We could actually pull back, but at the same time, we could do things to maintain our function within the community, both for licensing and for compliance work. But the budgets of the department was a very big factor, yes.
Would you agree that it was the principal reason for promoting the changes in 2015?
Look, from my perspective, it would have been a major to principal. You know, that's a very high priority. As the head of the department, I knew we were going to have trouble to balance our budgets.
All right. Now, the GWC is a separate entity to the department, isn't it?
Yes.
And the GWC has the ability to request appropriations from the government to carry out its functions?
Well, I presume we could put a case, not that it ever did in my time, it could do.
Yeah, so was any consideration given by you at least, as chairman of the GWC, to, if you like, solving the budgetary constraints of the department by requesting allocation of resources to the GWC?
No, because I just knew how hard it was to get money out of ERC, irrespective of the government, irrespective of whether it was the Gaming Commission or the department. I think from many perspectives, we were one and the same.
All right, I'm going to have to ask you again, Mr. Sargent, just to slow down. You may have seen it in that way, that you're one and the same, but did you not consider the possibility that if you did ask for purposes of the GWC, then funding may become available if you made a case for it?
It could have done, but at that time, I didn't see that there was any chance of getting something. But look, it was possible to put a case.
Now, I think I'm right in saying, I think you left the position of Director General in the middle of 2017.
Yes.
But you remained on the GWC as an ordinary member thereafter.
What happened was a month. I left on the 30th of June, And on the 1st of August, I took up an appointment as an ordinary member of the commission, yes.
Okay. Now, do you recall whether after 2015 there were some changes to the way in which shifts were rostered at the Perth Casino to essentially increase the amount of shifts that were undertaken by government inspectors at the Perth Casino?
What time frame are you talking about there?
Early 2017.
That would have been possible through the way in which resources were allocated, but I haven't got specific recollection of that.
All right. You don't have a specific recollection of there being an increase in the amount of inspectorial presence at the casino in 2017?
No, but it could have been easily accommodated through the rostering arrangements. There was flexibility to do that. I can recall at a briefing early in the year, the manager, Mr. Radis, had said he had a priority to make sure that there was someone out the casino most of the time, and whether that would have been possible to do. But on a day-to-day rostering basis, I don't think that information would have come through to the commission. I'm not aware of it.
To the commission or to you as Director General?
No, well, it wouldn't have come through to me as the Director General because it was just an operational matter.
So
it was an operational matter.
Decision made by the operations, person in charge of operations, Mr. Radis, is that right?
Well, Mr. Radis, he would have, that would have, if there was issues, he would have raised it up to his director, then of course to Mr. Connolly, but Mr. Radis would have had the ability to, and flexibility. There was monthly meetings when they used to talk through, I understand, the forthcoming work program. Okay, the monthly meetings, they talked through the programs, and there was flexibility to change things. And sometimes there might be more pressure in something. Other times they could move the resources. So there was flexibility. It wasn't rigid. It was not rigid.
Did you mention a little earlier in response to an earlier question that you had a conversation with Mr. Radis around this time?
With who?
Mr. Radis.
I just mentioned that it would have been earlier this year that I can recall Mr. Radis when he came in to talk to the commission. He had, because I asked the question of him, people keep saying we took inspectors out at the casino, and my understanding was we didn't take casinos out. We didn't take inspectors out of the casino. What we did, we changed it. There was always a presence, and he made the comment. He tried to get as much presence at the casino as possible through his rostering arrangements. So he had that flexibility to do that.
I see. So is that your answer in part from having reviewed his evidence or watched him giving some evidence to this commission, is it?
No, it was at a meeting of the Gaming and Wagering Commission before I finished my term. He was coming in on matters, and I asked him a specific question about that. All right.
Did you understand from any conversations you had with Mr. Radis that he was of the view that the reduction in the inspectorial presence in 2015 was detrimental to the ability of the department to carry out its inspections?
He didn't use the word detrimental. He just said that he thought it was the best interest to have a presence out there as much as possible. And that's not inconsistent with what I would have expected. Although they weren't rostered to start there, there'll still be a strong presence of inspectors out there.
In your view, if resources were not a constraint on the department...
Sorry, what the resources were not?
Resources were not constraining the department. In your view, would a more effective regime of oversight involve permanent inspectorial presence at the Perth Casino?
No, not necessarily permanent. To make sure we could roster people on, probably more.
So let's forget the word permanent, but a greater presence of government inspectors would be a desirable outcome.
Well, if it was possible, it would be desirable in some circumstances. But the crucial audit programs were being conducted. But obviously, a lot of things, more people are doing something, probably the more comfort we had.
Have you, in the course of the last year or so, have you had an opportunity to consider any of the evidence given to the Bergen inquiry?
I haven't. I've only read through it. I didn't go through in the detailed evidence provided. No.
Are you aware of any of the evidence that Mr. Preston gave to the Bergen inquiry concerning inspectorial presence?
No, I can't recall that. I was very interested in what was said about the Riverbank account more than anything else. That was my main focus.
All right. Well, Mr. Preston expressed an opinion that the presence of 24-hour a day, 7-day a week gaming inspectors from the regulator was a positive control. Would you agree with that?
Well, I think I can understand saying that because it gave them comfort as much as it would give other people comfort. But no, I don't think you need a 24-hour. I think you work on a reduced amount as long as you've had sufficient resources going into it.
So is the answer no? You don't agree that 24?
I don't agree with him. No, you don't need 24 hours.
And why do you say, leaving aside constraints of resources, assume you have an adequately funded regulator, why in your view would it not be desirable to maintain a 24-hour a day, 7-day a week presence of government inspectors at the casino?
Well, there are times when there's very little activity out at the casino, very early in the morning. There are certain things that are done then because of the lack of activity, purely on the basis of what they would be doing there. Now, bearing in mind that when you're rostering people on 24 hours, there's a degree of inefficiency as the hours get by, particularly for people working on some of the night shifts. I can recall when we were looking at rosters, this is one of the positives about a couple of our staff who were ex-police officers who had experienced rostering, and we could have rostered at times to get a much more efficient presence, but it would not be very, very good from the point of view of the health of the people. So I don't think you needed a 24-hour presence, no.
What about a return to 20.5 hours then?
Well, you could return to 20.5, but I would suspect that the number of hours that were out there, if you had inspectors out there for about 8 or 9 hours and you had the time cover, you'd cover for something like 18 hours. So look, 20 would be okay, but I don't necessarily say that you must have a particular target. It's a matter of what's been ordered and what you're trying to achieve.
You mentioned that you thought that maybe one of the reasons driving Mr. Preston's view was the benefit to the casino operator of having a government inspectorial presence. What is the perceived benefit to the operator that you?
Well, the fact that it means that rather than them have to probably be checking, they know somebody else is doing things on their behalf. So when the casino was first opened, very much the government inspectors did a lot of activities and functions in respect to the controls, and over time the government inspectors came out of that and the casino had to pick them up. But that's all I can say, but I've never discussed that with Mr. Preston.
Now, I take it, without you knowing every clause or section of the Act, you have a degree of familiarity with the Casino Control Act and the Gaming and Wagering Commission Act and its provisions.
I don't know if I've still got it. My memory is not as good as it used to be.
I'll put it in general terms. You understand that the GWC has the power to regulate the casino operator through the provisions of the Casino Control Act.
Yes.
It can give directions, for instance.
It can give directions over, I think, their internal controls.
Yes.
I think
Now,
actually the county manuals or things like that in the actual section of the Act, it's not a broad power, it's a narrowly defined power in which you give directions.
well, earlier this year, you were still a member of the GWC when it gave a direction concerning junket operators, premium players, and privileged players, correct?
Yes.
So it has the power at least to make directions as to who the casino operator can do business with.
I think we might have had some advice to say the actual direction we had given, it was not sure that it actually would achieve what was hoped to be achieved because of the powers, but that wasn't resolved by the time I left the Commission.
Well, in any case, the Commission, at least earlier this year, purported to exercise the power to control who could effectively be a patron of the Perth casino.
Well, it doesn't stop them being a patron, it stops them coming in under a junket program. We haven't got power to stop anybody from being at the casino. We can't bar them, but you could stop them coming in as part of a junket program. They could still come to the casino.
Well, you can stop them being a premium player.
Yeah, in that sense, I'm saying the nature in which they come in, junket premium player. It wouldn't be. The intention was you wouldn't be paying them commissions, etc., in relation to their activity.
So it was to deal with a particular way in which the casino was operated as regards junkets and premium or privileged play.
Correct.
All right. Now, the police have a power under the Casino Control Act to ban individuals from going onto the casino premises, don't they?
The only two have it is the Commissioner of Police and the licensee. That's
Yes.
to ban entering the casino.
And are you aware of any instances in the time that you were the chairman of GWC or the Director General where the Commissioner of Police, based on information provided to him by the GWC or the department, exercised the power under Section 26?
No, I'm not aware that the Commissioner ever exercised the power, even from his own information source under Section 26. I can't recall one instance that he actually, or she, that they exercised that power.
I want to return to a topic that I think we covered not in great depth in May, but I think you've dealt with it in both your witness statements, which is the subject matter of the repeal of the junket regulations in 2010.
Yes.
And just to put these questions into context, that occurred after the Crown Perth, or Burswood, as it may have then been called, made a submission towards the end of 2009.
Yes, I recall that.
Can I just perhaps, if we call up GWC point 0002.0016.001, sorry. This can't be displayed. It's subject to a non-publication order. And the pinpoint begins at _0337. Oh, Mr. Sargent's disappeared. Oh, you're back.
Did I get lost, did I?
You momentarily disappeared into the ether, yes. Now, have you got the document in front of you? Is it up on the screen, Mr. Sargent?
8.2, the gender item?
Yes. I take it you have re-familiarise yourself, become reacquainted with this document in the last few months?
I have, as a particular interest in the questioning that the Commission has made and in respect to the information side, which I wasn't aware of.
Yes. Now, again, you were responsible for preparing the papers that went to the Commission in this period in 2010.
I wouldn't use the word responsible, but I would, before the agenda went out to the Commission members, I would review it.
Yes. And did you review this paper in the early part of 2010 before it went to the Commission?
I would have reviewed it if it was on the agenda, yes, it would have come through.
And did you support the recommendation and the resolution in respect of it?
Yes, I did. Although I think the recommendation was to consider amending it didn't actually say recommend to Commission amend the consent. I said to consider amending. Isn't that the recommendation?
Well, the minutes.
That I don't disagree. The minutes say it was approved. You said about the agenda recommending, and it was put to the Commission to consider, and I was happy to do that. Yes. And I accept what the minutes might read. Yeah.
All right. And the resolution was to recommend ultimately to remove that aspect of the regulations, wasn't it?
The approval of the junkets only, yes. That's what the resolution was, the approval of the junkets and operators and representatives, yes.
Now, you'll need to juggle a little here, Mr. Sergeant, your first witness statement and your second.
Give me the paragraph for the first one, please.
Just 79, the first one. You might recall you asked some questions about something the Commission termed as the risks.
This was, yes, okay.
In 79, you gave a partial explanation for the reasons why those regulations were repealed. And then in your more current witness statement, paragraph 46, you make reference again to this process. And I just want to, paragraph 46 is quite brief. I just want to understand if there's any more information that you can provide to the Commission to assist it. If the document is still up, there were two reasons given in the paper for considering removal of the regulations. The first was that entry of a person into Australia is overseen by, in effect, the federal government departments controlling the border. And that appears on that first page on what was being said by the casino operator. And it's quoted. And the second reason in support given was to do with Crown Perth having in place an AML CTF program that required it to take certain steps in relation to junket operators and junket representatives. They were the two reasons given. Were those reasons the reasons that you relied on to yourself support the resolution to remove the regulations in 2010?
They were. On the other side of it is the fact that we weren't adding value to the process because we were not able to get police clearances on the junket operators, and we were actually, from what I recall, giving interim approvals, which we could do. Those interim approvals basically became permanent approvals because we weren't getting information from the police in regard to the probity of those individuals.
All right. Now, I understand that you had a view about the effectiveness of the GWC's processes. Could I ask you to take you to page 0346 and the conclusions of the author of the paper? And I'd like you to draw your attention to the paragraph under the heading conclusion.
Okay, I've read that.
Do you accept that the objectives of the junket approval process, at least prior to 2010, was to prevent criminal involvement in the junket market?
Yes, I'd accept that proposition, yes.
And so would you accept then that the GWC as the regulator of the Perth casino has a role to play in the prevention of criminal involvement in the junket market?
Yes, it would.
And do I understand from the answer you gave to my earlier question about the reasons for changing the regulations is that you were satisfied in the early part of 2010 that the risks were adequately catered for by the checks by the federal authorities on entry into Australia and by compliance with Crown's AML CTF program?
I think there would have also been some comfort in that we did have, excuse me, in those days, like the National Crime Authority, we would have also had the Australian Federal Police and of course our local police department as well, who could have information about them. But fundamentally, the first, we were placing reliance on the border controls coming into Australia, and secondly, the procedures that at that stage, I think it was still very much a Burswood decision, but rather than a corporate decision, it was a Burswood decision.
When you say a Burswood decision, are you making, is it a reference to the AML CTF program?
That and who comes in. I think it was at that stage, it wasn't so much the Crown corporate view, it was Melbourne and Perth running. There's a degree of independence between them. In the latter years, it became more that the Crown group took more control of vetting of the junket people coming into Australia. That's what I understood, but it was very much more around a Perth decision.
All right. So the second criterion then, if to paraphrase what you just said, was the Crown, we'll call it Burswood at the time, Burswood, or the licensee's processes for approving who were able to undertake junket in Perth.
I'm sorry, I lost you then. It's I won't repeat it because I got a bit of a crackling.
The second criterion was you were satisfied by the processes the internal processes of the Perth casino for approving junket operators.
I was, based on the advice of my officers, yes. Basically, going through the people that have prepared the paper.
All right. Now, in your most recent witness statement, in paragraph 49, you have indicated you have no knowledge of the Australian Border Protection Authority's process, really, in answer to the question about what you understood their processes to be for permitting entry of foreign nationals into Australia. Is that speaking of today or 2010?
That's more current. At 10, I might have had a briefing, but I haven't had a briefing on this for a long time. in effect, Mr. Connolly in the early years was very much involved in these aspects of the casino operations, and he was giving us advice on things to do with the money laundering and etc. So I would have relied very much on him and his team for this sort of information.
All right. So what did you understand the process to have been in 2010 for border checks?
Honestly, I can't recall what. I would have just been briefed on it then. I can't recall.
The paper that went to the GWC doesn't describe the process, though, does it?
No, it doesn't. It doesn't. But I can recall getting a briefing from someone, but I can't recall that now. I'm sorry.
So what information was made available to the members of the GWC then in 2010 to satisfy them that the process at the border was going to prevent involvement of criminals in junket operations?
I can't recall. I mean, I don't know what it was, and I can't recall what went to the meeting. I can't recall.
You can't recall, or there wasn't any?
Well, I can't recall either way. From that point of view, I can't recall either way.
All right. Well, what was your understanding of the the Perth Casino internal processes that gave you the sense that they would prevent approval of, if you like, junket operators who may have links to criminal activities?
Well, I can recall them bringing them in and getting the forms, etc. And they were using, I forget it, it's some sort of agency. The only example I can give is like in Perth, if you wanted to check somebody, you can go to Dun & Bradstreet for an independent assessment of someone's creditworthiness. I think there was an agency that they were employing that had international reputation for giving them some background on the people. That's what I can recall.
All right. Now, did you understand their process to be one where they made their own internal decision based partly on information from third parties as to whether they would accept or approve a party to operate junkets in Perth?
I understand so. And I understand that their processes were subject to their normal corporate risk management processes.
And did you understand that within that process they could approve a person to operate junkets in Perth, even if that person was known to have engaged in money laundering?
Well, my view would be that they shouldn't be approving people that are involved in money laundering.
Did you understand their process to be one where they could nonetheless have approved someone who had been convicted of money laundering or associated with money laundering in the past?
Well, it's possible that they could have done, but I think their own risk management processes should have addressed that sort of issue. But yes, I can accept that.
So was it your expectation that the internal processes of Crown Perth or Perth Casino would have been sufficiently robust to prevent approval of junket operators with associations to organised crime?
Yes.
And what information was provided to you by Crown Perth to satisfy you of that?
At that time?
Yes.
I can't recall.
Was any information provided to you by Crown Perth at that time to satisfy you?
I didn't meet with Crown Perth myself. I don't recall meeting with them. It's just so hard to recall that far back. I can't recall what the process was.
All right. Now, did you understand that, at least insofar as the border controls were concerned, that if a person had a criminal record, they would be excluded from entry into Australia?
Well, that was my understanding, but that was the whole process of the border controls.
Right. Now, would you accept that a person does not need to have a criminal record in order to be a criminal?
I think I'd have to accept that proposition, yes. Does not have a criminal record to be a criminal. Okay.
Now, did you also understand that a junket operator authorised to carry out junket operations in Perth was able to utilise the services of a junket representative?
That was normal process. So the junket representatives had to be licensed as well.
Yes. Now, a junket representative may not have a criminal record and could enter Australia. Correct?
Yes.
Whereas a junket operator may have a criminal record and be excluded from Australia.
Well, they wouldn't be classed as a junket operator then if they were not able to, if through the processes the Crown was adopting, they shouldn't be approved as a junket operator. But what you're saying, if they were, they couldn't get in because of their criminal record. They could then rely on a junket representative.
Correct.
Yes, I can understand that. Yes.
So relying on the border protection would not prevent people who were not without criminal records entering Australia and carrying out junket operations.
But to the same extent, we weren't getting information either, which would stop. We might have been able to stop a person getting a junket licence, but if you want a representative person in the same circumstance, if they didn't come up with a criminal record, not that the police were necessarily providing it, the Australian police or WA police were having to give a national clearance for WA or Australia, but it had no validity in regard to getting something from the jurisdiction which that person came from. So we were not adding value to the process because we could not get access to the information. Now, we were licensing them, giving them what we call interim approval.
Mr. Sergeant, I'm again to slow down. You're going to have to slow down again. You're speaking very quickly. Would you accept this proposition that in effect the integrity of the junket and the junket operators in Perth depended almost entirely on Crown Perth's internal controls?
Yes, it did. Because yes.
Now, the GWC has power under the Casino Control Act to give directions and to, in particular, with respect to how they carry out their operations, including approval of junkets. Correct?
Well, they've got the power through the processes by which you would license, etc. Yes, we could cover that through a direction. But that's why in the amendments which were made to the Casino Control Act in the late 90s to bring in through the Act rather than through directions, was I think there was some concerns about whether the directions were sufficiently robust enough. So that's why the Act was amended in about 98 or 99 or something. Regulations were promulgated, which stayed in place until 2010. So we could have gone, if we were concerned about it, rather than rely on directions, we could have gone back in to reintroduce regulations to control it.
At the time the regulations were removed, was any consideration given to adopting a procedure or imposing a procedure on the Perth Casino that required them to carry out particular probity checks and provide that information to the GWC?
I can't recall that being considered, no.
In paragraph 50, you have indicated that for a time after the repeal of the regulations, Crown Perth provided some information regarding junket operators and junket representatives to the department. You said you can't recall what that information was. do you have any recollection of the person who was responsible for receiving and reviewing that information?
No, I don't. It would have been part of the inspectoral program, so it wouldn't have been to a particular officer, but it would have eventually been sent from the casino out at Burswood into the Hyatt Centre where our office was. I would suspect it wouldn't be maintained, that information maintained wherever it is out there at the casino.
Do you understand or do you recall what the purpose of receiving the information was for?
Well, if we're going to be licensing them, then no doubt you'd want to know who was coming in, and then after that, you would be able to check if you need to. For instance, if the police required it. I think when a premium player was coming in, or a person was part of a junket, if they came into Australia, they weren't doing any more checks. We weren't doing any more checks to see their credibility, or sorry, their probity as a player. So I would imagine that information was being collected, but I don't know for what purpose it would have been used, other than if the police were interested to know, or another body, but mainly the police.
Well, for example, do you know if the GWC or the department's behalf was collecting information about the checks that Crown Perth was undertaking, the decision-making process they were making to approve junkets, and the rationale for approving a particular junket operator or junket representative?
I don't recall that being the case, no.
Now, in a risk-based approach to regulation, that is all information that could have been provided to the GWC and assessed from a risk perspective, is not?
Well, it wouldn't have to have been provided to GWC. If it was something which was seen as a priority, even the department could have taken it as an issue. But the GWC could have looked at it, yes.
What I mean to say is it was within the power of the GWC and through it the department to institute some form of audit or checking to consider the probity processes of Crown Perth for the veracity of that process.
Yes, the authority for that would have had to come from the GW, from the Casino Control Act, yes. Yes.
And so why wasn't such a procedure put in place?
I can't give you an answer other than the fact that there was confidence in the casino operator, would apply appropriate standards to their client base, the people involved in the management of the casino, and that is the boards, etc., the reputation of those people and their risk management processes would cover that. It wasn't something that that was expressly considered by the Commission.
The answer to that question, Mr. Sargent, leaves one with the impression that you placed an enormous amount of trust and reliance on the integrity of the casino operator.
I think that is a fair comment.
And would you agree with the proposition that the role of a regulator is to approach regulation with a degree of scepticism?
That's fair, but I mean, during this period too, there was sort of an what you call red tape sort of issues to do with government imposing standards on people. There was this idea that even in the banking system, more of a co-regulation model, whereby there was a degree of trust in the case of the casinos, the licensee wouldn't do anything improper to jeopardise their licence, and of course to jeopardise the reputation of the various boards of directors, the board of directors, etc.
Well, was there anything that took place in the period between 2014 and prior to the Bergen inquiry that gave you cause to pause and think about whether the trust you had placed in the Perth casino operator was misplaced?
Well, the first one that comes to mind was the Four Corners show in late 24. I wasn't in Australia when that program first was aired, but I did view it, and we did consider it from the commission point of view, the allegations. I know Mr. Connolly did some work on that. I can recall that one of the things that I had determined because it was about the Chinese market, the Four Corners show in Macau, was that my trip to Macau, I was seeing some of their high-end and high-roller rooms, and in effect, what they were doing in Macau was just subcontracting their part of their rooms out to the junket operators who ran them like a private casino. And I knew that wasn't happening in Perth, so I was quite confident in the process by which we operated. I can't recall the report that Mr. Connolly prepared, but I think as a commission, we were satisfied with it. There was some consultation with the casino operator. How
did you know it wasn't happening in Perth?
Well, the manner in which the casino was operating and our inspectors, it meant that they couldn't operate as a private sort of suite of individual rooms. These in the case of Macau, what I saw was they had signs up to show that this belonged to a certain particular junket operator and it was exclusive to their use. Well, that wasn't the way in which Perth operated.
Did you understand the way in Perth operated to involve the exclusive uses of parts of the...
Sorry?
Did you understand the way in which junkets operate in Perth was to allow for exclusive use of part of the gaming floor?
What do you mean? For when they came in, but they could have exclusive use, but they weren't in a situation where they controlled everything.
And how did you know that? How did the GWC understand?
Because the fact is we still had audits going into the cage audits and international room audits to be conducted, and there was nothing suspicious that was coming through to say that they weren't complying with the requirements. That's all I can say. I had never received any adverse, or came to the Gaming Commission, any adverse reports to that effect.
All right. Now, you've given evidence in your statement that you watched the Four Corners program in 2014?
Late to 2014, yes, I did view it. I can't recall the specific details anymore.
And the report does contain some quite serious allegations, doesn't it?
It did have some allegations. I think they were probably directed more at Melbourne than they were at Perth, if I remember correctly. But that's much as my recollection.
Either way, we're not at all concerned after watching that program that perhaps relying on federal border controls was not a sufficient control of junket operations for Perth.
No, I'd say not. No. Border controls.
You say that they were not adequate, or you didn't consider?
No, I was not dissatisfied with their controls. No, I was happy to still rely on their controls.
All right. But in answer to my question about whether there was anything that sprung to mind or began to cause you to...
Sorry, you have to repeat yourself.
I think in answer to a question I asked earlier about whether there was anything that took place between 2010 and 2017, or sorry, prior to the Bergen inquiry, that caused you to reflect on the trust you placed in the Perth casino operator, you immediately mentioned this.
Well, that's one. I was looking at the time frame. That's the one who came to my mind. If you wanted, you said before 2017. The other one was, of course, the Chinese arrests, which came to the fore. Now we did look at that. Now, in the case of the Chinese one, and because of the relationship between Crown and I think it's Melco, the company which ran the casinos in Macau, when Crown sought approval to get involved with Melco in the casino in Macau, it had to be approved as a close associate. We work closely with the Victorian authorities because they had the investigative skills to do that work. And I think we did something which I can't recall what part of it, but I know I went to Melbourne and attended one of their meetings of the commission there when they were deciding on whether to approve Melco. So as a result of this, Mr. Connolly had contacted Melbourne, and the decision was, yes, they're going to investigate. So we were happy to cooperate, but let them take the lead in relation to the matters in relation to the 2016 arrests of Chinese people. We had some assurances too. I think Mr. Felstead had rang me a couple of times and assured me that everything was above board. I actually relayed that to the commission, just verbally about that matter. But there was some follow-up, but I think the ultimate result was that, well, if Melbourne authorities are going to investigate, we'll rely on the Melbourne authorities.
Well, relying on the Victorian regulator to undertake the investigation is one thing, Mr. Sargent. What did you do as the Director General of the Department and the Chairman of GWC to consider whether the protections in Western Australia were adequate?
Well, I did nothing other than what I've just said. We went to the Victorian authorities.
So when you answered the question by saying this Four Corners episode gave you pause, what did you do?
What did you say?
When you answered my question by saying there was this Four Corners thing, you've mentioned the China arrests that gave you pause, what was done about that by you?
I mean, nothing. Well, the only thing is to get the reports from the Chief Casino Officer, and then to I had discussions with Mr. Felstead, and then I did refer it to. We were looking at working with the Melbourne authorities over the matter, but as an individual item, we let it stand.
Did you continue yourself to have absolute trust and confidence in the Perth casino operator?
Given the assurances I was given, yes.
All right, I want to ask you about a slightly different topic, Mr. Sargent, which concerns the regulation, the system that you use, the department used to calculate the taxes, the accounting information. And you referred to this in paragraphs 41 and 42 of your statement, and this involves the change from the RG system to something called Sharper Light. And again, you've been quite brief in your answer here, but there's some things that would be useful to put some of this statement into context. So, starting with the RG system, do I understand that system to have operated correctly, whereby the department had direct access to Crown Perth's accounting information?
I understand that. That's the basis of the system, yes.
So it had source information from which the department could calculate the appropriate amount of tax payable by Crown Perth.
Yes.
And when the Sharper Light system came into existence, that direct visibility was lost, is that right?
Yes, that was a decision we had to make about going across the Sharp Light, yes.
So you no longer had access directly to source information but relied on Crown Perth to provide you with information about how the tax was calculated. Is that the...
That's right.
All right. Now, the control that you put in place to deal with that was to undertake an audit through Gaming Laboratories Australia, or GLA. Is that right? Because they have the capabilities of doing that work. I understand, yes. So could I just want to again take you to some materials. ask you some questions. If you can fill in some gaps in our information, please, Mr. Sergeant. So the first is GWC.0002, 0.0008, 0.0001, which is an extract from a GWC agenda paper from December 2015. And I don't know, this is something you've been provided recently, Mr. Sergeant, but could I ask you just to have a look at the paper and see if it has a degree of familiarity to you in terms of the process at least?
In a particular report, no, it doesn't, but I know that we did rely on GLI to give us some commission, in particular, some assurance that the system was generating the revenue figures that it was alleging to be able to provide.
All right. Could I ask the operator to move to page _0008? And there are summary of findings and recommendations, two headings, Keno revenue, and the other one, trackside revenue. In fact, you should probably read following page as well, which is 0009. I'm particularly interested in the recommendations of the GLI Group Australia.
Sorry, which page are we going to?
Sorry, it's _0008 and then _0009. Mr. Sergeant, you'll have to let the operator know when you need to scroll down to get to the end of the.
Okay, go down. I've done 3.3. Trackside.
We can go to the next page.
3.8, yeah. On demand access.
Scroll down, please. I think he's finished reading.
So, Mr. Sergeant, have you finished reading?
That's normal. It's okay.
Yes. So I've got another document to show you, Mr. Sergeant. Just so if you can hold that information in your head for the moment. This one is GWC .0002, .0008, .0002, which is the corresponding paper from 2017. And in this, could we, as for the other reports, please navigate to the findings and recommendations on page _0012. Have you read that?
Yes.
So
So,
the question I want to ask you about is, there's a recommendation that the department have access to the psycho system to generate supporting reports for game revenue. And there's a recommendation to do with standard operating procedures. I've lost the reference to for the moment. Yes, in the following paragraph in under the heading in 4.3. And access to the standard operating procedures. It appears as if the recommendations from the 2015 report were not implemented before this report in 2017. Are you aware of whether, following from 2017, the recommendations in this report have since been implemented?
no, I can't. So I have. Was that 2017 was after I was no longer DG, not that I was a member of the Gaming Commission, but I can't recall receiving a report to indicate that they have. I can't recall that.
So is it, you don't recall receiving a paper from the department as a member of the GWC dealing with these recommendations?
No, I can't recall that.
All right.
I don't think we did. But what date in September was that one? Sorry, in 2017. What date was that?
This was at a meeting, I believe, in August 2017.
Yeah.
All right. Mr. Sargent, you were asked some questions about delegations in your
Yes.
topics, you might recall, and you've given some answers in paragraphs 26 to 31 of your statement. I would like to ask you some more questions about this topic to try and understand better what you mean in answers in some of these paragraphs. There was I think this is alluded to in your answer, there was a very general delegation of the powers of the GWC to the chairman of the GWC. And I would like to take you to what I believe to be an example of that, which is at GWC .0002.0016.0082.
I was basically given full powers of the Commission from day one, if I remember correctly. The chairman had those powers to exercise the full powers.
Yes. There seem to have been a number of iterations of it, but
In principle, it remained the same.
correct. And I just want to confirm. So if we could go to page _0201 and sorry, 0202, which is an attachment to the paper. So this is the nature of the delegation that you're referring to in your statement, is it not? That there was effectively a delegation of all powers, save for the power of delegation itself.
That's right.
And a similar delegation was made to the deputy chair.
What date was that one?
The same document.
What date?
Scrolling down to underscore 0204.
The deputy chairman's powers only came into effect when the chairman wasn't available, so it wasn't unfettered to the chairman. The way the act was structured, that for instance, if I was away and not available, then the deputy chair could step in. But that was basically the way in which the deputy chair would have operated. Fundamentally, the powers rested more with me than to the deputy chair.
Well, that qualification doesn't appear from the instrument itself.
Wouldn't it fly through the act? That's what I was just thinking. The fact that it's the deputy chair only applies when the chairman is not available. But I'd stand corrected on that. Yeah.
All right. Well, whenever it's operative, you would agree, though, it's a very, in theory, it's an unlimited power, save for the power of delegation itself.
Yeah. But I can't recall it being exercised to that extent. I was very careful on using any of the powers under the Act, and I can recall things like, well, when we were having some issues to do with some of the standard lotteries, sometimes we were requiring them to go to full commission meetings, and for some reason they would get held up by the officers, and rather than penalise some of the people, I'd give them I'd approve things which the commission had sent over the commission to do in relation to getting at least one permit out so they wouldn't be adversely affected. Things like the TAB, the TAB might forget to send in a request to authorise a temporary TAB or some event. I could do that, but it was. I think I might have once changed a gaming rule because there was an error in it, but that's the extent to which it was exercised. And you'll find that over the course of the years, I very rarely exercised the discretions that I had in that relationship.
You're now talking about how you operate in practice. I'm more interested in what power it gave you in theory, from a governance perspective.
It gave me unfettered power.
And do you consider that to be an aspect of good governance on the part of the GWC to give the chair an unfettered power?
Well, although it didn't say in the delegation, I knew that the powers were basically to be exercised in cases where the commission couldn't meet or something, or it was not of a major concern that I could exercise those powers. So I'd had them since I started. They were just given to me from the start. So I was very comfortable with it. I know what you're saying about the broad parameters that wasn't spelled out, but obviously the commission had confidence in me exercising those powers. But it was unfettered. I accept that.
But the understanding you've just described, that is an unstated understanding of yours, is it not?
Sorry, you broke up a bit.
The understanding that you would only exercise, I think you've said in your statement, you had a good feel or words to that effect.
Yeah.
That's an unstated limitation on your power that you personally felt, is it not?
It was unstated, but whenever we had these issues or to sign, that was the basis on which they were signed by the full commission members.
Well, this question was asked in part because there are references to, in some of the minutes, to the exercise of a power under delegation, and there's a reference to general matters. I'll give you an example of that. GWC.0002.0016.0037 underscore 0012, and apparently this is subject to a non-publication order. So on this page, this is underscore 100012. There is an express reference to, for want of a better way to describe what I think you have just articulated, which is you'd exercise the power with respect to general matters.
Can someone blow that a bit bigger for me, please, Lynn? Well, I think that's a fair description of that particular case. Nothing major.
So is it fair to say then, leaving aside the strict legal interpretation that we all as lawyers can do, that the practice in your mind was you exercise the power with respect to what you might call general matters or routine matters, and anything major would be left to be determined by the full commission?
Definitely. So the examples I gave you to do with standard permits or permits for temporary this, that was a very standard sort of general matter which we did, and there might have been some reason why they were coming to the commission at some stage, and I would have exercised that power under circumstances which I thought was justified. And I'd report that back to the commission though.
All right, but in any case, whichever way it's done, the decision about whether to bring it to the commission before or after the exercise of the power was yours.
Mm-hmm. Yes.
As a matter of good governance, do you not consider it to have been preferable to describe and circumscribe the power at the outset?
If you use that term, good governance, yes, I'd have to agree with that, but obviously I had confidence in myself and the commission had confidence in me as well, but yes.
So to put it slightly differently, what was the point of delegating such a broad power to you if it were never intended to be exercised so broadly?
Well, it was a matter of what you were saying is you could have put it into the delegation to describe it, but that was the understanding which was granted. That was all I can answer that on.
Okay, now there's that's dealing with you and the delegation to you of the powers. There was a delegation I took you to the deputy chair who,
Yes.
who may or may not have been the same person as the chief casino officer, because the delegations work to a position, not to a individual.
Yes.
Now, can I ask you to be shown GWC.0002.0016.0056? Again, this is subject to a non-publication order. And you'll see there's a recommendation to delegate certain powers to the Chief Casino Officer in 1A, and then the Deputy Director General in 1B. And then if I could take you to the minutes of that meeting, which is at GWC.0002.0016.0059 underscore at, this is the page reference 0006. This non-publication code?
This page is fine.
Okay, this page is fine. Excellent. We can show you this one. Now this...
Can you give me the date of that again? I didn't pick it up. Can you just tell me?
This is 23 April 2012.
April 2012. Yeah.
And in the case of the Chief Casino Officer, you'll see that the nature of the delegation is more limited. It's limited to specific things, including issuing a direction under the Section 24 of the Casino Control Act, for example. Now, in the minute itself, there's no requirement that after exercise, the delegate of the power report on the exercise of the power to the GWC.
And so there's nothing in the minutes to require them to report. Is that what you're saying?
No requirements. So the minute doesn't say, for example,
Okay.
this resolution, delegation, and you must report on use exercise of the power.
I can't give an explanation. Well, the explanation I give was expected that you would report back, and as a matter of course, we did report back out the times that we exercised that delegation.
Okay, well, I was going to ask you about that because in paragraph 29 of your statement, you said there was the CCO and departmental officers were expected to report the exercise of delegated power back to the GWC. From where does that expectation come?
Well, it just comes from the understanding that anybody that's delegated those particular powers would report back to the Commission. The ones that didn't report back to the Commission, that those that had delegated power to issue licences and very mundane things, otherwise the Commission meetings would be just bogged down with it. There was no need to report them back. But in relation to those broad powers, it was just an understanding that that's what would happen.
Where does the understanding come? How does the delegate know that is the way in which the power is to be exercised?
Like myself, it wasn't to be exercised in very major items. It was more routine items to be done under delegation. The preference always was to do things at the Commission meetings. Now, I don't think it was at that stage, but at some point, with respect to games, the Commission was approving things, and all the materials coming back to the Commission again, and the Commission delegated the power to the Chief Casino Officer then to approve games once they'd been approved in principle, and there was no need to report back those particular cases. But it wasn't explicitly set out, but there was an expectation that you would report back.
Well,
I think it did happen.
leaving aside you and what you understood, because obviously you can speak directly to your own experience, how did the Chief Casino Officer, to whom the power was delegated, if there was, say, a change in the person occupying that office, know that they were acting under an expectation or understanding that they would report the use of the power to the GWC?
Well, in this case, the Chief Casino Officer and the Deputy Director General were one and the same. That was Mr. Connolly. And I think he, like me, understood the parameters under which delegations were made, and I would have made it quite clear that any time you exercise the power of that, you do report back to the Commission, and I think he did. I can't recall him not reporting back to the Commission.
But the person occupying the office can change?
Sorry?
The person occupying the office does not need to be Mr. Connolly in perpetuity.
But it could. I agree, it could change, but in that circumstance, it had remained that person for quite some time. Like I could have changed too. Well, I did change in 2017.
Yes.
Changed from my position to Mr. Ord. So it does change, but in the case of Mr. Connolly, he'd been there since 2011 or 2012 or something. I can't recall to that position.
So is the answer that you conveyed to the delegates of the power the expectation that they would report to the GWC?
In the case of Mr. Connolly, yes, it would have been. And he attended many meetings of the Commission as well, before then and now even after the meeting. That's my understanding. Sorry,
when you say would have been, is that a positive recollection? You did it, or is that you thinking you did it?
I use would have been in relation to him reporting or him coming to meetings. I can't recall.
You're conveying to him the expectation that upon exercise of the power, there would be a report to the GWC.
I just expected he would. That was the understanding, that he would report back to the GWC the exercise of those powers, similar to the way that I had reported back the exercise of those powers.
The expectation was not from you telling him, by the way, Mr. Connolly, when you exercise this power under delegation, you need to report back to the GWC. You just thought he should know that. Is that what you're saying?
No, I would have spoken to him, but I can't recall how I would have spoken to him. But there was that was the expectation. I don't know. Would have had to put it strong the words that you put it in. But I can't recall how. But that was the expectation, and I could imagine if when we're putting this particular matter to the Commission, that was the way in which we were expressed, that there would be the expectation of reporting back.
All right.
I can't recall instances of matters being delegated and proved on a delegation that hadn't come back, but that doesn't mean to say it could have happened.
Well, there was a discretion, wasn't there, as I understand what you've said, on the part of the delegate.
Sorry, that was it.
As I understand your evidence, the expectation was they would report exercise of power where the exercise involved a significant decision, not a routine thing like they're going to issue a permit for a bingo game or something.
I agree. That delegation, no, because we're inundated with work. There had to be. They were other officers even further down the line that were issued that power. It's just like in the liquor area, the Director of Liquor Licensing delegated the power right down for people to sign things on behalf of the Director. Similarly, people signed permits, etc., on behalf of the Commission to authorise those people to play those games. That was not reported back to the Commission.
Now, leaving aside cases of urgency where there's a need to make a decision before the GWC can meet, would you agree with the proposition that a change to the casino manual is a decision that ought to have been the subject of a meeting of the GWC?
I can't recall, but I thought the manual side was actually considered as a Commission matter, but if it wasn't, then most of the matters that were being done in relation to the manuals were of the sort of a general matter. They weren't necessarily major changes of philosophy. That was the intent. All
right. A deletion of a section and insertion of a new section, is that major or minor in your view?
But it depends on the circumstances. If you aren't changing things dramatically, but you are rewriting a section, I wouldn't necessarily think that was major. I'd have to look at each case on their merits.
So each case on its merits, discretion to the person to whom the power has been delegated to make that decision.
It would have been in that case, yes.
Do you consider that to be an aspect of good governance on the part of the GWC?
Well, it's a matter of confidence in the individuals exercising the powers, and I didn't consider there was not having a trust in the individual exercising those powers. So from that perspective, I don't think it would have made any difference. If you documented it, well, obviously that puts certain certainties in place.
All right. Can I call up GWC .0002.0016.0299 at _0010. I'm just going to take you, Mr. Sergeant, direct to the minutes of a meeting. And in this instance, under 9.3, there's a reference to a delegation to the Deputy Director General.
Mr. Futrell, could you just identify what document we're looking at?
Sorry, I thought I had. It's GWC 0002.
No. What the title of the document is? Just. You
It
said
is-
it was the minutes.
Oh,
of
it's
a
the minutes of a
but
meeting of the
could I-
GWC of 28 April 2020.
Thank you.
And if I could ask you to look at 9.3.
This was to do with the sale of the TAB, I think, was it?
Well,
Oh, sorry, can you give me the date? Sorry, to give me some.
it's 2020, 28 April 2020.
Yeah, I think it was to do with matters to do with amending the legislation to facilitate the sale of the TAB.
Well, all right. So the minute refers to that. In a sense, as a qualification in Roman 5. But to use the French expression chapeau, in the chapeau to the resolution, the delegation is of all of the Commission's powers, other than the power of delegations itself, and then there's the qualification too.
What was that one?
Well,
Sorry.
to expedite the approvals process, etc., for transitioning.
And to enable the position holder to exercise and so matters that may require attention between Commission meetings.
All right. Now, can I ask you to be shown GWC .0001, .0007, .0184. That's the instrument of delegation signed. I take it the third signature is yours.
One of my signatures there, isn't it?
Yeah, under members.
Yeah, there.
Can we scroll down, please?
Sorry, can we scroll down?
Yeah, I would have been there at the meeting. Yeah.
Well, that's your signature, isn't it?
Yeah, no, that's that. It's either I would say that because it's essentially not electronic, no, that'll be mine. Yeah.
Now, this instrument of delegation doesn't contain the qualifications that were in the resolution. It's purely and simply a delegation of all the powers of the Commission to the Deputy Director General of effectively the department.
And was that from that particular meeting? This was the instrument of delegation from that meeting.
Well, it's dated the 28th of April 2020 and it's signed by you. And
Yeah, but I'm saying, was it that from the meeting, the paper that you just showed me?
the minutes were
That is an outcome of that particular meeting. That's what I'm asking.
correct, same meeting. So,
Yeah.
although at the time the Deputy Director General of the department was also the chief casino officer and deputy chair of the GWC.
Yes.
On its face, this instrument is purporting to delegate all of the powers of one statutory body to the Deputy Director General of the department.
Is there a question there, Mr. Futrell?
No, there's not.
Look, I acknowledge the fact that if that was the paper that came and that's what we did, I accept the criticism of that. For me personally, other members, that's up to them. But yeah.
Well, there's no requirement to report in the instrument, is there?
No, I accept that. Actually, I left that would be electronic signature, I think, because I'm sure that I was locked out of Perth at that stage, or due to COVID, that I was doing it by thing. But that makes no excuse. I'm just trying to put into a context whether I was there at the meeting by Teams or not. But
as far as you're aware, has that instrument been revoked?
I think it's all the delegations were revoked early in 21, and they were starting afresh. I think that delegation has been revoked.
Okay. Mr. Sargent, I'd like to ask you some questions about the events of 2017. And you have dealt with the topic of the compliance review in your statement at paragraph 68 and
68 was it?
68, yes, and 69. I'll take you to the document because I think you've referred to it in paragraph 68, which is GWC.0002.0016.0202. This is subject to a non-publication order, and the pinpoint is _0013. Now, the context to this review. Now, you gave the direction, didn't you, to Mr. Connolly to undertake a review of all gambling and liquor compliance activities performed by the department?
Yes.
And the purpose of that was to assess the effectiveness of those programs and the processes and practices employed?
Yes.
And at this, it was intended to cover, amongst other things, junket operations.
Yes.
And do I understand that the impetus, or one of the impetuses, to your direction was the conclusions in the Victorian Auditor, Office of Auditor General report concerning the Victorian VCGLR.
Yes.
And was it your concern that the finding of the VOAG that the VCGLR had not paid sufficient attention to areas of risk in the Melbourne casino's operations, such as detection of people excluded by the Victoria Police, responsible gambling and money laundering? Was it your concern that a similar finding could be made regarding the GWC's regulation of the Perth casino?
Yes, so you wouldn't have it probably in relation to the police barrings, but and it was yes, an opportunity to say, well, we need to look at ourselves, bearing in mind that I knew I'd be retiring within 12 months at least of then. And in fairness to Mr. Connolly, he had talked about the need to review our operations, particularly after we had changed the inspectorate in relation to their audit of the casino. We had a couple of redundancies we'd paid out, so it was timely. It was timely.
All right. Now, I want to show you a document that you may or may not have seen before. It is, the reference is DLG.001.0023.7494. This is also subject to a non-publication order, and I thanks, excuse put that there so I don't. Now you may need to have a good look at the document, Mr. Sergeant. At the foot of the page, it's dated 16 February 2017. My question is whether you recall having received it in or about early 2017.
No, I haven't seen that document before. I've only seen it as a result of some documents which the Royal Commission supplied to Queen Emmanuel. Until then, I'd never seen it before.
So do I understand from the answer that you've just given that you have had an opportunity before today to read through it and familiarise yourself with it?
Very short amount of opportunity, but it's just to have a very short opportunity.
Perhaps
I hadn't seen it, not aware of it having been distributed to anybody.
in fairness to Mr. Sargent, if you know or have an idea who created it, where and when, you could put that to him to assist him to put it into any context?
I'm not sure I know the answer to that question.
That's fine if you can't.
Mr. Sargent, I want to ask you some questions about some statements that are attributed to Vanessa, if I can name this person, a person,
Yeah.
on page 3 of the document, under a heading Corporate Junket Operators.
When I read that document, it's the first time that I've seen those sort of issues being raised, and
Right.
I was very concerned to read them.
So you've mentioned in paragraph 64 of your statement that it wasn't raised with you at the time. That
64, what was that I said?
your statement, you said you have no knowledge of those concerns in February 2017.
In relation to this document, is that the one I'm saying it to?
My apologies. In your witness statement, in paragraph 64, in answer to a question.
Yeah, I see. No, that's correct. I have no knowledge of it until I read it in the for this particular.
Okay.
Yeah.
Now, Mr. Connolly had been directed to undertake a review of the compliance, if I call it compliance framework of the department.
Yes.
In 2017. Someone records a conversation with the relevant compliance inspector in this document, and I think you have alluded to a concern about the nature of the allegations being made by that inspector in terms of the junket operations at the Perth Casino.
Yes.
As the Director General of the department at the time, is this a matter of which you would have expected to have been made aware by departmental officers?
Yes. If you take the wording there that Ms. Webb said she's been raising concerns, well, my concern is, well, why hadn't that filtered up the system before? And there should have been some reports on it if there was issues out there. But I was very concerned to read it when I read it for this exercise.
So, is it your evidence, is it that no one in the department, to use the phrase escalated these allegations to you as Director General or as Chair of GWC?
And the date the 17th, I can't remember what was the date of Mr. Connolly's memo to the Commission. You just said what date was that?
The memo to the accompanying the GWC materials is the 21st of February 2000.
Well, I would have expected if that was it, it should have been even saying it was a matter of urgency, something to do with the junket markets. But if that was the 16th of February, I think you said, didn't you? 16th of February, that was on that document, 17th? Or, so it preceded, but this preceded the report that Mr. Connolly had prepared for the Commission.
That's right. So these things may have been running together, Mr. Sargent. My question really is whether you can recall today whether one of the reasons for your direction to Mr. Connolly in February 2017 was knowledge of these allegations being raised by an inspector.
Definitely not.
Would you agree with me that if the raising of allegations of that nature concerning activities at the Perth Casino would suggest that some of the criticisms made of the regulation in Victoria could be levelled at the regulator in Perth?
I would agree. I would agree. And the way in which if they were using those rooms like they use them in Macau, I'd be very concerned about it.
And why is that?
Well, it's because the nature in which they conducted their junkets in Macau, whereby they basically took control of rooms. I think it was mentioned in that there was telephone, people on telephones to people. I know they had come before to the Commission some time about telephone betting, and the Commission had said no to that. So whether there was allegations of telephone betting for games at the casino, just having total control, I would have just liked to have known a bit more about it. Now, there might have been good reasons for it, but that would have raised my concerns at that stage.
Was your concern, or is your concern now reading it, that if activities of that nature were taking place at the Perth Casino, it made the junket operations ripe to be used for money laundering? I wouldn't suggest ripe for money laundering, but there was questions to be asked about how they were operating the junkets, but more importantly, how the licensee was operating junkets. I'd be concerned about that as a first point. now might be a convenient time.
Mr. Sargent, we will leave it there for the afternoon, and we'll be continuing your evidence tomorrow morning. If you could be back where you are in time to recommence at 10 a.m. tomorrow morning.
Yes.
Thank you very much. We may now turn the link off.
Thank you. Good night.
Thank you. And we will adjourn until 10 a.m. tomorrow morning.